Duty to disclose. Under Florida law, a seller has a duty to disclose known material defects in a property that are not easily discoverable by a buyer. These latent defects must be those that are significant and that would make a buyer reconsider had he or she known of the defect. A defect that is observable or one when the buyer knew or should have known falls outside of this duty. Active concealment. In Florida, a seller is prohibited from actively concealing defects in a property. A seller cannot take steps to conceal the discovery of known material defects. Intentional misrepresentation. Intentional misrepresentation occurs where one party intentionally misrepresents facts to another party. Negligent misrepresentation. A negligent misrepresentation exists when a party has a duty, usually in a professional capacity, is negligent in disclosing or not disclosing facts that the other party relied on to their detriment. Remedy. The buyer's legal remedy or equitable remedies will depend on the type of deed provided because any promise contained in the sales contract merge with the deed. There are two types of deeds, quitclaim deeds and warranty deeds. A quitclaim deed makes no guarantees as to the quality of title or on the property, while a warranty deed contains 6 covenants which are, season, right to convey, warranty against encumbrances, breached at time of closing, warranty of further assurances, warranty of quiet enjoyment and warranty of warranty, breached after closing. Contract formation. Contracts for services are governed by the common law. For a contract to be valid, we need an offer, acceptance, and consideration. An offer is the outward manifestation of an intent to enter into a contract with certain and definite terms communicated to the offeree. Acceptance occurs when the offeree communicates an intent to enter into a contract. Consideration is a bargain for exchange. In Florida, consideration needs a benefit or legal detriment. Under the mirror image rule, acceptance must mirror the terms of the offer. Any change in the terms results in a counteroffer. A counteroffer is a rejection of the original offer and places the power of acceptance of the new terms in the hands of the initial offeree. Acceptance can also take place with performance. Statute of frauds. Statute of frauds requires that certain contracts be in writing, contain essential terms, and signed by a party to be signed. These contracts are contracts that cannot be completed within 1 year, contract for marriages, contracts for the sale of land, executorships, guarantees, and the sale of goods over $500. Liquidated damages. Natalia can argue that the early termination fee is not liquidate damages and is a penalty. Liquidated damages must reasonable and a reasonable forecast of the damages in the future. Contract formation. Contracts concerning real property and services are governed by the common law, whereas contracts for the sale of movable goods are governed by the UCC. Since the alleged contract at issue is one for the sale of computer chips, movable goods, Section 2 of the UCC applies. A valid and enforceable contract requires both mutual assent, offer and acceptance, and consideration. A valid offer is an objective manifestation of the offer or to enter into an agreement, creating the power of acceptance in the offeree. An acceptance is an objective manifestation of intent to be bound by the terms of the offer. In Florida, consideration can be both a benefit and a legal detriment to the promisor. Additionally, the terms of a contract must be reasonably certain and a contract must contain the essential elements. For UCC contracts, the only essential element is quantity. While under the common law, the acceptance must mirror the terms of the offer, under the UCC an acceptance containing different/additional terms will not automatically invalidate the contract. If 2 merchants enter into a contract under the UCC, and the acceptance contains terms that are additional to the offer, the additional terms will be incorporated as part of the contract unless, 1. The additional terms materially alter the terms of the offer, 2. The other party objects to the additional terms within a reasonable time, or 3. The offer limits acceptance to the terms of the offer. If the acceptance contains conflicting terms with the offer, then the battle of the forms approach applies and the conflicting terms will be knocked out. A merchant is a commercial entity that deals in goods of the kind at issue. Statute of frauds. Chipco could argue that the statute of frauds, SOF, should preclude enforcement of the contract. Under the SOF, a contract for the sale of goods worth $500 or more must be in writing and signed by the party to be charged, in this case, Chipco. A writing does not have to be a formal contract, but can simply be written evidence of a contract. Additionally, a handwritten or electronic signature is not required in order to satisfy the signing requirement. Even a company's logo or letterhead will satisfy the signature requirement. Anticipatory repudiation. A breach of contract is material when the breaching party fails to substantially perform according to the terms of the contract. A breach of contract can occur when one party repudiates the contract before performance is due. A repudiation must be clear and unequivocal, otherwise the non-repudiating party may only demand further assurances. The repudiating party may retract the repudiation unless, 1. The non-repudiating party has relied on the repudiation to its detriment, 2. Has sued for breach of contract, or 3. Has 26 accepted the repudiation. In the case of repudiation, the non-repudiating party must suspend performance in order to avoid further loss to the repudiating party. Remedy, cost of cover, expectation damages. Expectation damages are meant to place the parties in a position as if the contract had been performed, and to give the parties the benefit of the bargain. The non-breaching party has no duty to mitigate damages, i.e., failure to mitigate does not operate as a bar to recovery, but if there is a failure to mitigate damages, then this could reduce the amount of damages. If a seller breaches a contract, then the buyer is entitled to expectation damages. If the buyer must replace the goods, the damages are measured as the difference between the contract price and the cost for replacement. Consequential damages. The non-breaching party has no duty to mitigate damages, i.e., consequential damages are recoverable under the UCC. Consequential damages that include lost profits are available only if at the time of contacting the breaching party knew or had reason to know of the nature of potential losses, and such losses were a foreseeable event as the result of breach at the time of contracting. Contract formation. This is a contract which would require, under the common law, this is not a sale of goods covered by UCC 2, that there be mutual assent, offer, acceptance, and consideration. The contract is not required to be in writing. Statute of frauds only requires writing for certain contracts like service that will take more than 1 year. Common law requires mirror image, meaning the offer and acceptance must mirror each other. Duty to disclose. Under Florida law, a seller has a duty to disclose known material defects in a property that are not easily discoverable by a buyer. These latent defects must be those that are significant and that would make a buyer reconsider had he or she known of the defect. A defect that is observable or one when the buyer knew or should have known falls outside of this duty. Active concealment. In Florida, a seller is prohibited from actively concealing defects in a property. A seller cannot take steps to conceal the discovery of known material defects. Intentional misrepresentation. Intentional misrepresentation occurs where one party intentionally misrepresents facts to another party. Negligent misrepresentation. A negligent misrepresentation exists when a party has a duty, usually in a professional capacity, is negligent in disclosing or not disclosing facts that the other party relied on to their detriment. Remedy. The buyer's legal remedy or equitable remedies will depend on the type of deed provided because any promise contained in the sales contract merge with the deed. There are 2 types of deeds, quitclaim deeds and warranty deeds. A quitclaim deed makes no guarantees as to the quality of title or on the property, while a warranty deed contains 6 covenants which are, season, right to convey, warranty against encumbrances, breached at time of closing, warranty of further assurances, warranty of quiet enjoyment and warranty of warranty, breached after closing. The UCC applies to the transaction. The UCC, Article 2, applies to all transactions in goods, defined as movable things. Because a painting is a movable thing, the UCC applies to this transaction. Valid contract formed. Formation requires 1. An offer, 2. Acceptance, 3. Consideration, and 4. No defenses to formation or enforcement. An offer is an objective manifestation of an intent to enter into an agreement on specified terms. Acceptance is a manifestation of assent and a desire to be bound to the terms of the offer. Under the common law mirror image rule, acceptance needed to be to the exact terms of the offer. Under the UCC, however, acceptance need not be to the exact terms so long as there is a sufficient match between the terms of the offer and acceptance to constitute a meeting of the minds. The acceptance is not effective if it is conditional, however, it is a counteroffer in those circumstances, a rejection and new offer. Consideration is a bargain for exchange of a legal benefit or legal detriment. Perfect tender. Under the UCC, the perfect tender rule generally applies, unless it is an installment contract. When a seller tenders goods that fail to conform in any way to the underlying contract, the buyer typically has 3 options. She may, 1. Accept the goods, 2. Reject the goods, or 3. Accept in part and reject in part. The buyer is entitled to sue for damages for any non-conforming goods, regardless of whether they are accepted. Statute of frauds. Under the UCC, a contract for a price of $500 or more must be in writing to satisfy the statute of frauds. The writing must be signed by the party to be charged and manifest the essential terms of the contract, typically by identifying the parties, the goods, a quantity, and a price. Generally, the writing must contain a quantity term. Courts may fill in most other terms by implementing reasonable terms, so long as there is a meeting of the minds. The signature requirement is broadly construed. Any document authenticated by attaching an insignia is considered signed. When both parties are merchants, there is a special rule surrounding confirmatory memos. A confirmatory memo between 2 merchants that is sent by one to the other and identified will bind the party to whom it was sent if the party does not object in a reasonable time, 10 days. A merchant need not read the contents of the memo. The memo is effective upon receipt of possession. Acceptance. Generally, acceptance must be in any reasonable form that manifests an intent to be bound. However, any conditions the offeror puts on effective acceptance are generally enforceable. Parole evidence. The parole evidence rule bars use of contemporaneous oral or written agreements that contradict a writing evidencing an agreement, or supplement a complete integration. However, oral agreements are admissible to clarify ambiguities, or supplement partially integrated agreements. A patent ambiguity is one that appears on the face of the document. A latent ambiguity is not apparent on the face of the document. Furthermore, Scrivener's errors can be corrected through the equitable remedy of reformation if the writing does not reflect the mutually agreed on terms of the agreement. Liquidated damages. A liquidated damages clause is a clause providing for a specific remedy upon breach of a contract in lieu of legal damages. Typically, legal damages in a contract action are designed to compensate the non-breaching party by putting them in the position they would be in had the contract been performed, expectation damages. For sale of goods contracts, this typically includes incidental damages as well as the non-breaching party's loss in value. A liquidated damages clause is enforceable when prospective damages are too speculative. They must be reasonable in light of the anticipated and actual cost of the breach. Lastly, the clause must not function as a penalty. Merchant confirmatory memo. Between two merchants, terms included in a confirmatory memo are sometimes included as part of the contract when not objected to, the battle of the forms. Although when one of the parties is not a merchant, all deviations are considered mere proposals. If the change is non-material, it often comes into the contract without being specifically agreed to. Specific performance. In regard to unique goods, the equitable remedy of specific performance is often appropriate. Specific performance is only available when the legal remedy would be insufficient. Perfect tender. Under the UCC, if a seller tenders non-conforming goods before the goods are due, the buyer must allow a reasonable opportunity to cure, typically, up until the date the goods are due. However, if the non-conforming goods are tendered on the due date, the seller does not have a right to cure unless the seller had reason to believe the goods would be accepted. Valid contract. A valid contract requires offer, acceptance, and consideration. Governing law. Important to note at the outset that these are both contracts for personal services, therefore the common law of contracts will govern the disputes. Whereas the UCC would govern a contract for the sale of goods. Valid contract. A valid contract requires offer, acceptance, consideration, and no valid defenses. An offer manifests the power of acceptance in the offeree must know of the offer, and the offer controls the manner of acceptance. Acceptance is the manifestation of assent to the terms of the contract and can be done in any reasonable way and within a reasonable time unless the offer specifies. Finally, consideration is the bargain for exchange of legal value. Breach. Under the common law, a contract is breached when one party has an absolute duty to perform and the duty has not been discharged. Material breach, where a party is denied the substantial benefit of the bargain, discharges the other party's duties under the contract. Minor breach is where a party receives the substantial benefit of the bargain, though imperfect performance, does not but allows for damages for defective performance. Additionally, the plaintiff will need to show that they are ready, will, and able to perform. Parole evidence. The parole evidence rule bars extrinsic evidence from before or contemporaneous to formation from coming in as a term to the contract. If the contract is a final integration, i.e. it contains a merger clause, then only evidence that explains the meaning of the contract, of industry standard, of the party's course of dealing, or substantiates a defense to formation may come in. If it is a partial integration, then extrinsic evidence will be permitted unless it materially alters the terms of the contract. Specific performance. It is important to note at the outset that specific performance of employment contract is usually not permitted as it creates 13th Amendment concerns. However, injunctions to enforce valid non-compete agreements will be enforced. Non-compete agreements. A covenant not to compete must be, 1. Aimed at protecting a valid business interest, 2. Reasonable in terms of time and geographic scope, and 3. Must not be contrary to public policy. Fraudulent misrepresentation. If a party is induced to contract by a fraudulent misrepresentation, it is voidable by the injured party. Bob will argue that Sun Company fraudulently misrepresented that he would be eligible for a bonus in order to induce his assent to the employment contract. If he is successful, Bob may rescind the contract. Bob will look to restitution to recover the value of the benefit conferred if his employment contract is set aside. Breach of contract. A contract is an agreement formed following an offer, acceptance of the offer, and consideration. Statute of frauds. The statute of frauds requires that certain contracts must be in writing and signed by the party to be charged to be enforceable. This includes agreements that cannot be completed within 1 year. Damages. Generally, a non-breaching party to an enforceable contract is entitled to compensatory damages. Where possible, a non-breaching party can recover expectation damages, which are intended to put the non-breaching party in the position she would have been in had the contract been fully performed. Incidental damages. WLAW may also recover incidental damages, which will include those costs incurred that were reasonably foreseeable in ameliorating the breach by locating a new radio personality. Consequential damages. The non-breaching party has no duty to mitigate damages, i.e., consequential damages are those damages arising out of the breach that were reasonably foreseeable at the time of the contract that the breaching party should have known were reasonably foreseeable as a result of the breach, including business losses. Non-compete. Although restrictions on an individual's ability to be employed are disfavored, non-compete clauses are enforceable, at least to a limited degree. The court will closely scrutinize the non-compete clause and will enforce the clause only if I. The non-compete clause protects a legitimate business interest, 2. It is no more restrictive than necessary to protect that interest, and 3. It is sufficiently limited in scope and duration. Absent a showing of unique circumstances, courts will not enforce non-compete clauses for more than 2 years. In Florida, there is a presumption that non-compete clauses for a duration of less than 6 months are reasonable and that non-compete clauses of more than 3 years are not enforceable. Breach of contract. Breach of contract. A breach of contract claim is a legal vehicle for enforcing a promise. To succeed in a claim, a party must assert 1. An offer, 2. Acceptance of the offer, and 3. Consideration. Offers and acceptances are measured according to the reasonable listener standard in Florida. A statement or action will constitute an offer or acceptance if a reasonable party viewing or hearing it would conclude it was an offer or acceptance. But if the actual offeree in a given situation has reason to know the offer is not serious, then the parties will not form a contract. A promise to perform can be valid consideration for a contract. And in Florida, consideration is met if the party gives a benefit or incurs a legal detriment. Unilateral mistake. Unilateral mistake exists if 1. A factual mistake exists at the inception of the contract, 2. The mistake goes to a material aspect of the contract, 3. The party asserting mistake did not incur the risk of it, 4. The mistaken fact was an essential fact on which the mistaken party relied, and 5. The non-mistaken party knew of the other's mistake but did nothing or it would otherwise be unjust to enforce the contract. Statute of frauds. A promise must be in writing signed by the party to be charged under the statute of frauds if it 1. Relates to the sale of $500 or more in goods, 2. Relates to the sale of land, 3. Is a promise in consideration of marriage, 4. Is a promise of suretyship, or 5. Is a promise that cannot be complete within 1 year. In this case, the only one that might potentially work would be the 1-year provision, but that will not work. It only applies if it is impossible to complete the performance in a year, and here they were just buying tickets on a week-to-week basis with no set end point. Governing law. The applicable law will depend on whether this was a contract for goods subject to the UCC or a contract for services subject to the common law. Modification. Under the common law, a modification to a contract must be supported by new consideration. Promissory estoppel. Alternatively, Lori could claim damages under a promissory estoppel theory. The elements of promissory estoppel are 1. The defendant made a representation, 2. The plaintiff reasonably, foreseeably, and detrimentally relied on the representation, and 3. The court will enforce the representation to the extent necessary to prevent injustice. Restitution. Alternatively, Addie could claim restitution for the payments she sent. Restitution claims involve showing 1. The plaintiff conferred a benefit, 2. The benefit was not gratuitous or officious, and 3. The defendant had an opportunity to reject it but did not. Third-party beneficiary. An intended beneficiary of a contract has the ability to sue the parties to the contract to ensure its enforcement or otherwise collect damages. And the intended beneficiary's claim is subject to the same defenses as might be asserted against the parties. Condition. For a party to become liable on a promise, all express conditions precedent to that promise must be fulfilled. Moreover, the default rule is that parties must comply 100% with express conditions. Intended beneficiary. Moreover, FB was the intended beneficiary. 2 parties can agree to benefit a third party, and if that third party is an intended beneficiary, then that third party can enforce the contract. Contract formation. A contract is an agreement or set of promises that is enforceable by law. For there to be a valid contract, there must be mutual assent, which is a valid offer and acceptance of clear terms that both parties intend to be bound by, supported by consideration and no valid defenses. Consideration. Consideration is a bargain for exchange for something of legal value or a detriment to one party to the benefit of the other. Statute of frauds. A contract that is for a specified term beyond 1 year and cannot be performed in less than 1 year is subject to the statute of frauds, SOF. SOF requires the agreement to be in writing, signed by the party against whom enforcement will be sought. A writing can be in more than one document as long as it is clear it is referring to the essential terms of the agreement, and the signature can be by any method that indicates the party sought to be bound, such as a company seal or letterhead. Non-compete. Contracts that limit a party's ability to compete are valid as long as signed by both parties and are reasonable as to the geographic scope, subject matter, and time limits. Limitations on patents are deemed reasonable if the limit is 5 years or less. This is a rebuttable presumption. Mistake. When there is mutual ambiguity or mutual mistake that goes to an essential element of the agreement, and both parties were unaware of the ambiguity or mistake, the agreement may be rescinded and each party shall be entitled to claim in restitution anything they gave of value. If one of the parties is aware of the ambiguity or mistake and the other party is not, the contract may be enforced in favor of the party that was not aware of the ambiguity or mistake. Parole evidence. Parole evidence, PE, is evidence of oral agreements prior or contemporaneous with the agreement and are usually not permitted if the written agreement is fully integrated, i.e. that it is a full expression of their agreement. However, PE is allowed under the common law if there is an ambiguity or the agreement is not fully integrated, or to supplement the agreement as long as it does not materially contradict the terms of the agreement. Acceptance. An offer may be accepted by the manner indicated in the offer or by any reasonable manner. Performance is by implication, conduct, and acceptance. Mixed contract. The agreement is a mixed agreement of intellectual property, patents, and licensing of the kits, and a contract for the sale of goods. The UCC covers the sale of goods which are tangible movable property. DNA kits are movable goods and therefore subject to the UCC. SOF applies to contracts for sale of goods that are more than $500 in value. Mirror image. Under the CL, the mirror image rules require that an acceptance match the offer exactly. Any changes are deemed to rejection and a counteroffer. P signed the agreement but changed its terms by changing the fee. Battle of the forms. Under the UCC, which could apply to the text kit but not the patent, amended terms are only accepted if they do not materially change the offer, or the offer was not expressly conditional to acceptance of its terms, or the offeror does not object within 10 days. Accord and satisfaction. Accord and satisfaction. When there is a dispute as to a debt, a party that offers a lower amount in satisfaction of the debt and rights paid in full fully performs and is discharged. Contract formation. In order to have a valid contract, there must be an offer, acceptance, consideration, and no valid defenses. An offer is the manifestation of an intent to be bound by the terms expressed in the offer and provides the offeree the power of acceptance. Consideration must be in the form of legal detriment or benefit, Florida being in a minority of states on this matter, to both parties. Ads. Generally, advertisements are considered an invitation to negotiate, and not an actual offer. The only exception is where there is specific language which indicates how to complete the sale, such as a store advertisement stating first come, first served. Statute of frauds. Statute of frauds against Amy. The statute of frauds requires certain types of contracts to be in writing and signed by the party to be charged. Contracts for the sale of real estate, the sale of goods amounting to $500 or more, contracts in contemplation of marriage, contracts guaranteeing the debt of another, and contracts that cannot be completed in less than 1 year must be in writing and signed by the party to be charged. The party to be charged is the party against whom the contract is being enforced. Restitution. Restitution puts the parties back in the position they were prior to the contract, and expectation puts them in the position they would have been had the contract not been breached. Mailbox. Mailbox rule applies, which states that acceptance occurs upon placing acceptance in the mail, and not upon receipt of the acceptance. Misrepresentation. Misrepresentation, which requires a misrepresentation of a material fact, scienter on the part of the party making the misrepresentation, justified reliance, and damages. Offer. An offer consists of a manifestation of assent to enter into a contract. It must contain a promise to enter into a contract, and a contract for the sale of goods requires a quantity term and the parties' essential terms test. The test of determining whether a valid offer has been made is whether the offeree would reasonably believe that his acceptance of the offer would create a binding contract. Acceptance. Next, we must determine whether this offer was accepted. Generally, the offeror is the master of his offer and he can revoke the offer at any time prior to acceptance. Acceptance is when the offeree manifests his assent to enter into the contract. Acceptance, if not expressly agreed otherwise, may be done by any reasonable means. Battle of the Forms. UCC 2-207, the Battle of the Forms provision, will govern the communications between these two merchants. While under the common law, the mirror image rule applies to offer and acceptance, UCC 2-207 governs communications between parties governing their offer/acceptance. UCC acceptance. Under the UCC, acceptance can be by shipment of non-conforming goods. If the seller of goods would like his shipment not to be an acceptance, it must be accompanied by a notice of accommodation. If it were accompanied with a notice of accommodation, then we would have a counter-offer instead of acceptance and breach. Consideration. In Florida, there must be bargained for exchange of legal value for there to be a binding contract. Legal value in Florida, which follows the minority position, is that legal value is legal benefit or detriment to one of the parties. Statute of frauds. Statute of frauds requires that certain contracts be in writing and signed by the party against whom enforcement is sought. Here, this is a contract for the sale of goods for $200,000. Contracts for the sale of goods in the amount of $500 or more are required to be in writing, contain a quantity term, and be signed by the party against whom enforcement is sought. Merchant confirmatory exception. Under the UCC, there is the merchant's confirmatory memo exception. Under this exception, if the merchant receives a memo from the other party confirming the terms of the agreement and does not object within a reasonable time, this writing may be used against him/it to satisfy the statute of frauds. Modification of contract. Under the UCC, in contrast to the common law, there does not need to be additional consideration to support a contract modification. Rather, the UCC simply requires that the contract modification be made in good faith. Breach. Breach of contract occurs when the plaintiff has performed and the other party is under an absolute duty to perform and has failed to perform or has performed inadequately. Damages. Florida awards expectation damages for the party to get the benefit of his or her bargain. Contract formation. Here, the prima facie elements of valid contract existed, a valid offer creating a power of acceptance in the offeree, acceptance indicating an intent to be bound, and consideration, a legal detriment or benefit and bargain for exchange. Governing law. This contract was for the sale of goods subject to Article 2 of the Uniform Commercial Code, UCC, because a grand piano is movable personal property or chattel, i.e., a good. Statute of frauds. Since the exchange was for more than $500, the UCC statute of frauds applies, meaning that in order for the contract to be enforced, there must be a 1. Writing or memorandum, 2. Signed by the party to be charged, and 3. Containing information sufficient to indicate the contract was made. The UCC statute of frauds is liberal, requiring only the parties and the general good as an essential term. The UCC's flexibility is attributable to 1. Its gap-filling provisions, which fill gaps in the contract with default rules relating to price, shipment, risk of loss, etc., and 2. Its treatment of parole evidence. Parole evidence. The UCC allows parole evidence, even of an integrated contract, unless the parties certainly would have included a term in the written agreement. Fraudulent misrepresentation. Fraudulent misrepresentation exists when a party, 1. Misrepresents a material fact, 2. In a way amounting to fraud, 3. Inducing reliance from the other party, 4. To the other party's detriment, causing damages. Express warranty. There are 3 major kinds of warranties relating to the sale of goods. An express warranty is created by a particular express representation, statement, model, design, or sample, indicating that the good to be sold is of a particular status or quality, but not a general recommendation or commendation of any good. Warranty is the implied warranty of merchantability. This warranty applies only to goods sold by merchants. Here, seller is the owner of a piano store and so is a merchant. The implied warranty of merchantability is a warranty that the goods sold are fit for their ordinary purpose. Implied warranty of fitness of a particular purpose. This warranty applies to sales of goods by both merchants and non-merchants when the seller knows that the goods are purchased for a particular purpose, and the buyer relies on seller's skill or judgment in order to choose a good. Disclaimer of warranty. Warranties may be disclaimed, but generally such disclaimers must be specific and not hidden. When a disclaimer of a warranty contradicts an express warranty, moreover, the contradiction is resolved in favor of upholding the warranty. A generalized disclaimer, such as is often insufficient. This particularly applies to consumer goods, goods for personal or household use, such as a baby grand piano. Expectation damages. Expectation damages, which aim to give the non-breaching or innocent party the benefit of his bargain. As an alternative, in appropriate cases the non-breaching party may be able to recover restitutionary damages, reliance damages, or specific performance. Liquidated damages. Liquidated damages that are not penalties also may be enforceable, although this issue does not arise here. Also, a contract is voidable at the election of the party who entered into the contract as the result of a fraud, misrepresentation, or non-disclosure amounting to fraud, i.e., rescission is a remedy. Punitive damages. Generally, punitive damages are not recoverable in contract, unless there is an independent tort committed. Note that under the doctrine of election of remedies, a party cannot get a double recovery he cannot choose, for example, both restitutionary and expectancy damages. Specific performance. Specific performance is where a court uses its equitable power through a court order or decree to enforce the terms of a bargain. Usually, specific performance is reserved for unique goods that have no replacement on the open market, such as contracts for the sale or purchase of land or an interest in land. Specific performance is not available where there are adequate legal remedies, e.g., money damages, or rescission of the contract. Contract formation. To be enforceable, the contract must have an offer, an acceptance, consideration, and no valid defenses to formation or performance. Acceptance. An acceptance is a manifestation of intent to contract under the terms of the offer. In Florida, consideration to support a contract may be a legal benefit to one party, or a legal detriment to the other. Under common law and the UCC, valid consideration consists of a bargain for exchange. As this is a construction contract and not a contract for the sale of goods, the UCC's rules do not apply. Modification/statute of frauds. Under the statute of frauds, certain contracts must be in writing, such as surety agreements, services contracts exceeding 1 year, and sale of goods exceeding $500. Under the statute of frauds, the present construction contract does likely not need to be in writing, as it could be performed in a year. In addition, courts will generally not preclude proper modification of a contract based on a writing-only clause, where the parties manifest the intent to subsequently change the contract and the modification is properly effected. The statute of frauds and the writing-only clause would not bar modification of the parties' contract. Parole evidence. Parole evidence, however, is only prohibited to contradict or supplement an integrated contract with prior writings or prior and contemporaneous oral agreements. Evidence of conditions precedent, mistakes, or of subsequent modifications may be considered where necessary. Pre-existing duty/modification. Under the common law, contract modifications must be supported by separate consideration. A pre-existing duty to perform is not adequate consideration to support a contract modification. In contrast, under the UCC, a good faith modification suffices, without additional consideration. Impracticability. He would have to show that an unforeseen event, the non-occurrence of which was a presumption of the parties, materially altered his performance to such an extent that performance is excused. Contract terms. A contract generally needs to contain all essential terms, including identification of the parties, the price, manner of payment, and the obligations, and be signed by the party to be changed. Provisions regarding insurance or the failure of the party to obtain insurance will likely not render a contract unenforceable. Unilateral mistake. Generally, a unilateral error by one party does not stand as a hindrance to contract formation. However, where the other party knows or should have known of the error, he will not be allowed to snap up the benefit of the mistaken agreement. Applicable law. Article 2 of the UCC applies to sales of goods. Goods are all things movable. RCU are movable and thus, are a good, so the UCC Article 2 applies. Contract formation. For a contract to be enforceable there must be offer, acceptance, consideration or a valid substitute, and no defenses. Offer. An offer is a manifestation of intent to commit to a contract. It must have specific and definite terms. Under the UCC, a quantity must be stated. Acceptance. Acceptance is mutual assent to the contract. Consideration. Consideration is a bargain for exchange of legal detriment. Statute of frauds. The statute of frauds requires that contracts for the sale of goods of $500 or more must be in writing. The writing must contain the essential terms of quantity and signed by the party to be charged. Also, performance is another way to satisfy the statute of frauds. UCC gap fillers. However, under the UCC, whenever there is a term left open to be determined, the UCC has gap fillers which can allow the court to imply a term into the contract. Breach of contract. A breach occurs where a party does not get the substantial benefit of the bargain, or a breach is so material that it substantially impairs the non-breaching party. Under the UCC, a seller may be excused from performing under a requirements contract if the other party substantially increases their requirements. Modification, UCC. Under the UCC, a modification need only be done in good faith. Impossibility/impracticability. Enforcement of an agreement is impossible when there is no way a party can perform under a contract. It is impractical when there is an unforeseen occurrence that renders performing very difficult. Cover damages. First, under the UCC, Bud may elect to get cover. Bud may get the difference between contract price and the cost to buy RCUs from a new seller. Bud may also get market price, which is the difference between the contract price and the fair market value of RCUs. Expectation damages. The purpose of these damages is to put the plaintiff in the position he would be in as if the contract had been performed. Incidental damages. He may also get incidental damages, which is just any additional cost or expense Bud incurred as a result of sales breach. Consequential damages. The non-breaching party has no duty to mitigate damages, i.e., Bud may also get consequential damages if sales was aware of the potential for consequential damages and they were foreseen. Liquidated damages. Also, the contract provided for liquidated damages. If the court finds the contract enforceable, Bud may elect liquidated damages. Liquidated damage clauses must be reasonable. Unconscionable. An agreement is unconscionable when it is so one-sided that a court should not enforce it. Specific performance. Specific performance is appropriate when the good is rare or unique. Counteroffer. A counteroffer is considered a rejection of the original offer and the making of a new offer. By making a counteroffer, the seller effectively rejected buyer's January 30th offer, which terminates the offer, and made a new offer with different terms. The mirror image rule dictates that an acceptance must match exactly the terms of the offer in order to be an effective acceptance. Consideration. In Florida, consideration can be either a legal benefit to one party or a legal detriment to the other. Option contract. A promise to keep an offer open for a specified amount of time is considered an option contract and is only enforceable if valid consideration exists for the option. This is different than under the UCC, which uses the firm offer rule if the seller is a merchant. Acceptance. The terms of the offer control the method of acceptance. If not specified in the offeree may accept by any reasonable method. Modification. At common law, contract modifications must be supported by new consideration. In Florida, consideration is a bargain for exchange and can be a legal benefit to one party or a legal detriment to the other. The terms of acceptance must match the terms of the offer under the mirror image rule. Homestead property. Homestead property is subject to special rules designed to protect the spouse of the owner. Homestead property cannot be sold without the consent of the owner's spouse. Breach. There is a valid enforceable contract if there is an offer, acceptance, consideration, and no defenses. Specific performance. Specific performance is an equitable remedy that is available when remedies at law are insufficient. Remedies at law are insufficient when the subject of the contract is unique, such as real property. Damages, real estate. Damages would be calculated based on the market value of the property at the time of the breach minus the contract amount. Misrepresentation. Under FL law, a party under a contract commits fraud or misrepresentation if the following elements are met. 1. Made a false statement about a material fact. 2. Made it within the knowledge that it was false or didn't know if it was true or not. 3. Made the fact to induce the other party into entering into the contract. And 4. There was reliance on the party of the party and they were harmed. Contract formation. In order to have a valid contract, it must be shown that there was an offer, acceptance, consideration, and that there are no applicable defenses to its enforcement. Modification/consideration. In order for a modification to be valid under a non-UCC contract, there must be valid consideration for the modification. Consideration can be either a legal benefit or detriment. In the modification context, the promise to repay a debt as originally due is not sufficient consideration. Statute of frauds. The statute of frauds applies to contracts regarding interests in real property. The statute of frauds requirements for real property transactions are as follows. It must be in writing, must sufficiently identify the land and parties involved, it must be signed by the parties, and it must be witnessed by 2 subscribing witnesses. Where there is a modification to a contract, whether the modification itself must be in writing depends upon whether the contract, as modified, would have to meet the statute of frauds. Duress. Duress occurs where a party's free will has been overcome due to the circumstances surrounding the transaction, and as such, did not voluntarily enter into the contract. These circumstances can be found where one party has made an improper threat to another party that has caused that party to involuntarily enter into the contract. Third-part beneficiary. In order for a party to be a third-party beneficiary, it must be shown that they were contemplated as a beneficiary under the contract by the contracting parties. In order for a third-party beneficiary's rights to vest, it must be shown that they were aware of the rights, they assented to the contract, they detrimentally relied on the contract, or that they have brought suit under the contract. If the third-party beneficiary has done any of these things before the parties have revoked or modified, then the third-party beneficiary's rights have vested and they can enforce the agreement. Mutual mistake. Mutual mistake occurs where both parties have made a mistake about the contract, which goes to the core material terms of the contract. It must not have been possible for either party to have known of the mistake prior to contracting. If a mutual mistake is shown, it will relieve the parties of their obligations under the contract. However, a party asserting a mutual mistake must have assumed such risks in the contract. Typically, mere differences in value are the type of risks that parties have assumed in contracting, unless the contract specifically provides otherwise. Expectation damages. Expectation damages seek to place the non-breaching party in the position they would have been in had the contract been performed as contemplated. Expectation damages would include the repayment of principal plus the interest payments required under the loan. Under a land sale contract, where one party breaches, the non-breaching party can recover either specific performance or damages. Damages in land sale contracts are typically the difference between the fair market value of the land and the contract price. Reliance damages. Reliance damages seek to return the non-breaching party to the position they were in prior to the contract being formed, thereby returning funds and other items expended pursuant to the contract. Incidental damages seek to remedy damages incurred incident to the breach, such as inspection fees, storage fees, having to remarket property, etc. Consequential damages. The non-breaching party has no duty to mitigate damages, i.e., consequential damages are those damages caused by the breach, which prevents the parties from obtaining profits or other things as a result of the contract having not been performed as contemplated. Consequential damages must have been foreseeable to the contracting parties at the time of the contract. Specific performance. In addition to remedies at law, parties can also seek to recover under equitable theories. Parties can seek specific performance for unique items contracted for. Land is one of the items that is considered unique, because it cannot be replaced with another piece of land. The court will award specific performance where damages at law would be inadequate and it is feasible to do so. Restitution. In addition, parties can seek to recover any unjust enrichment conferred upon the other party even if the court finds that there was no validly enforceable contract under a theory of restitution. Misrepresentation. Misrepresentation occurs where a party makes a false statement of material fact that the plaintiff reasonably relies upon. Governing law UCC. The UCC governs transactions that involve the sale of goods, and the CL governs transactions that do not deal with the sale of goods and can apply to case for services. Merchant. A merchant is one who regularly deals in goods of the kind sold. Statute of frauds. The SOF requires that certain Ks be in writing, signed by the party, to be charged. This is to prevent fraudulent transactions. SOF applies to case 4, 1, case for marriage, 2, a K that is for longer than a year, 3, land sale case, 4, executory case, future case, 5, sale of goods over $500, 6, guarantors, 7, suretyships, and an FL, a few other Ks, such as a K for newspaper subscriptions. Offer. An offer is an expression of an intent to invite acceptance, which must include the essential terms, and puts the power of acceptance in the offeree. Modification. Modifications to contracts under the CL require consideration, but under the UCC do not require consideration. Unilateral mistake. Unilateral mistakes are those such as typographical error, computations, etc. However, this is only a defense if the non-mistaken party knew or should have known of the mistake. Mutual mistake. Acceptance. An acceptance is a manifestation of assent to the terms of the offer, either by express communication to the offeror of acceptance, or by conduct that is conformity with the performance that the offer invited. When the offer asks for a promise in return, it is a bilateral K. When the only way to accept is by performance, it is a unilateral K, whereby beginning performance makes the K irrevocable. Under the UCC, acceptance need not be the mirror image of the offer, as under the CL. Consideration. Consideration is a bargain for exchange, and in FL, it merely requires a legal detriment to one party or a benefit to another, or both. Specific performance. Specific performance is reserved for items that are unique in nature, such as land and antiques. Anticipatorily repudiated the contract. This is when a party breaches the K, clearly and unequivocally, before performance is due. Statute of frauds. SOF applies to case 4, 1, case for marriage, 2, a K that is for longer than a year, 3, land sale case, 4, executory case, future case, 5, sale of goods over $500, 6, guarantors, 7, suretyships, and an FL, a few other Ks, such as a K for newspaper subscriptions. Promissory estoppel. Promissory estoppel is when the promisor makes a promise that they could reasonably believe would lead to reliance on the part of the other party. The other party did in fact rely on the promise, and that party suffered a detriment due to their detrimental reliance. Restitution. Restitution is a type of damages that puts the party who relied back in the position they would have been had they not relied. Therefore, seller may counterclaim for the money that she turned down in reliance on Mary's supposed acceptance of the K. Governing law UCC. Applicable law. This contract is for the sale of goods and as such is governed by the UCC. Contract formation. To have a contract there must be offer, acceptance, consideration, and no valid defenses. Statute of frauds. Statute of frauds. Under the UCC, for a K for sale of goods to be valid it must be in writing, signed by the party charged, and must state a quantity, and give adequate language to indicate there is a contract. Further, SOF can be satisfied by delivery of goods in a K for sale of goods. Installment contract. When a K can be broken up into separate portions, where each portion has performance by each side, it can be deemed an installment contract. Material versus minor breach. When determining a breach, it can either be material or minor. To determine if it is material or minor, you look to see if the non-breaching party received the benefit of the bargain. To determine that, you look to see how much benefit has been given, likelihood the other party will perform, the cost of the other party having to perform. If there has been a material breach of the contract that the non-breaching party does not have to perform their portion of the contract and will recover any damages they incur in order to mitigate or cover for the breaching party's breach. Perfect tender. Under the UCC perfect tender rule, a party must deliver the goods in perfect condition on the exact quantity and quality as stated in the K. If the delivering party does not, then they have breached the contract and the non-breaching party may accept the goods, reject the goods, or accept any commercially reasonable units and sue for the rest. Impracticability. Impracticability occurs when there is an event that makes the performance of one party very difficult and the happening of that event was not foreseen by the parties. Anticipatory repudiation and adequate assurances. Anticipatory repudiation occurs when one party communicates unequivocally that they will not perform their part of the bargain before their time of performance has arrived. If anticipatory repudiation occurs, then the non-breaching party has 4 options. 1. Treat the contract as a total breach and sue immediately. 2. Wait for the performance date and sue. 3. Treat the contract as rescinded. Or 4. Do nothing and encourage the other party to perform. Damages. Modification. Under the UCC, a party need not give consideration as long as the modification was done in good faith. Implied warranty of merchantability. Generally, the implied warranty of merchantability holds that there are no defects in the products as sold. Implied warranty of fitness. Generally, the implied warranty of fitness doctrine holds that merchant sellers warrant that the product is fit for the general use for which it is intended. Warranty of fitness, for a particular purpose. Generally, when a merchant seller knows the particular purpose for which a buyer is intending to use a product, and thereafter warrants that the product is fit for that purpose, if the product fails, the seller is liable. Implied warranty of merchantability. Each merchant, a person occupied in the regular distribution and sale of products, impliedly warrants that the products that they sell are merchantable, that is fit for regular consumption and for the uses to which the products are usually put. In Florida, this implied warranty extends to not only the purchaser, but the purchaser's family and household guests. Valid contract. A valid contract requires offer, acceptance, consideration, and no valid defenses. The law governing contracts depends on the subject matter of the contract. The UCC will govern contracts for the sale of goods, and Florida common law will govern contracts for the sale of services. Under the UCC, a valid contract does not have to state all material terms. Rather, a contract under the UCC is valid if it is signed by the parties and contains a quantity term. Offer. An offer is a manifestation of intent to enter a contract by words or conduct that gives the offeree the power to accept. To be valid, an offer must have language of commitment and definiteness, i.e., details. Acceptance. Acceptance is the manifestation of intent to be bound by the terms of the offer. Consideration. Consideration is a bargain for exchange. Florida follows the minority rule in that consideration can be satisfied by either a benefit or legal detriment, or both. Merchant firm offer. Under the UCC, a firm offer is valid without consideration. Firm offers are valid for 90 days unless the contract states otherwise. Under the UCC, firm offers cannot be revoked for 90 days and arguably for any time longer than 90 days if the parties so intend. Mailbox rule. The mailbox rule does not apply under the UCC. The mailbox rule states that an offer is accepted upon dispatch, meaning upon placing the acceptance in the mail. Promissory estoppel. Promissory estoppel is the equitable doctrine for enforcing a contract when one party relies to his detriment on the promise of another. The key to promissory estoppel is reliance. Impossibility. Impossibility is a valid defense when there is a severe change that the parties did not contemplate in when they entered the contract that materially affects performance. Statute of frauds. The SOF requires certain contracts to be in writing to be enforceable. Under the UCC, the SOF requirements are relaxed in that it allows a promise for the sale of goods to be enforced, provided a writing contains the quantity and signature of the party to be charged. Valid contract. In order to have a valid K, there must be an offer, acceptance, consideration, and no valid defenses. An offer is an invitation to enter into a contract that is sufficiently definite to put the power of acceptance in the offeree. Statute of frauds. According to the statute of frauds, in order to protect buyers and sellers from fraud, certain contracts must be in writing, such as those in consideration of marriage, those that cannot be performed within 1 year, those for the sale of goods of $500 or more, and those for an interest in land. In Florida, the sale of an interest in land is subject to special SOF provisions. In FL, in order to satisfy the SOF, a land sale contract must be in writing, adequately describe the property to be sold, name the parties to the contract, the price paid, be signed by the party to be charged under the contract, and be witnessed by 2 subscribing witnesses. However, there are 2 exceptions to the statute of frauds that can serve to satisfy the statute if there is no formal writing: part performance and equitable estoppel. Part performance statute of frauds exception. Under the doctrine of part performance, in a land sale contract without a writing, the statute of frauds will be satisfied if a party does 2 of the following 3 things: 1. Pays all or substantially all of the contract price, 2. Occupies the property, or 3. Improves the property. Valid contract. Contract. To be valid, a contract, K, must contain 1. An offer, 2. An acceptance, 3. Consideration, and 4. No defenses. An offer is a manifestation of an intent to be bound plus the inclusion of any essential terms. Under the UCC, quantity is the sole essential term. Everything else can be supplied by gap fillers from the UCC. Acceptance is an intent to be bound. Consideration is a bargain for exchange, a benefit to one party or a detriment to the other. Statute of frauds. Under the UCC, a sale of goods for a price of $500 or more must be 1. In writing and 2. Signed by the party to be charged, in order to be enforceable. B could raise a statute of frauds, SOF, defense, however, it appears that it has been met. The writing required does not have to be a formal contract. Delivery. Under the UCC, a buyer has the option to reject the goods if it is not a perfect tender. After acceptance, a buyer may revoke the goods if the goods are substantially impaired and there is a good reason, for not rejecting them. Risk of loss. Assuming the seller made the delivery himself, as a merchant, risk of loss begins with the seller and passes to the buyer upon the buyer taking physical possession of the goods. Mistake. Both parties may claim that there was a mistake as to identity of the artist of the painting. If it was a mutual mistake, the contract could be rescinded because there was never a meeting of the minds. Misrepresentation. Misrepresentation occurs when one party 1. Makes a statement of material fact to the other party, 2. Knows the statement was false, 3. Intends the other party to rely on it, 4. The other party relies on the statement, 5. The other party is justified in relying on it, and 6. Damages result. Material breach of contract. A material breach of contract occurs when one party breaches the contract in a material way, changing the economic benefits or risks to one party. Market damages are the price of the contract minus the market price of the goods. Consequential damages. Consequential damages are those that flow from the breach. Specific performance. Specific performance is used for unique items and is a method whereby the court will order the other party to perform. Recession. Recession puts the parties back in the same position before contract was formed. Valid contract. In order for a valid contract to exist, there must be an offer, objectively discernible, acceptance of that offer and consideration to support the bargain. In a land sale contract, the agreement must be in writing to satisfy the statute of frauds. Assignment. Generally, contracts are assignable absent express language to the contrary. UCC. This contract will be governed by the UCC, as enacted in Florida. When the contract involves the sale of goods, UCC governs. The test whether the contract involves goods or services is the material purpose test. Offer, invitation to enter into a contract. Acceptance, manifestation of an intent to be bound. Consideration, in Florida, is either a bargain for exchange, benefit to one party, or a detriment to the other. Statute of frauds. An oral contract is generally enforceable unless it falls within the statute of frauds, SOF. Under the UCC, a K for the sale of goods of $500 or more must be in writing to be enforceable. In addition, it must be signed by the party to be charged and contain all essential terms. The UCC is liberal in including gap fillers where terms are not included, but the K must include the quantity. Exceptions to the statute of frauds. Part performance, specially manufactured goods, acceptance or completed performance, judicial pleadings. Contract with a minor. A minor, under 18, lacks the capacity to contract. A contract entered into between a minor and adult is voidable at the minor's option. It is fully enforceable against the adult. If the minor is emancipated or if the contract is ratified after the minor turns 18, then lack of capacity is no defense. Adult may be able to enforce contract for necessities, shelter, food, etc. Anticipatory repudiation. Anticipatory repudiation is when one party calls and unequivocally indicates an unwillingness to perform his obligations under the contract before his obligations for performance have come due. If there is an anticipatory repudiation, then the non-breaching party at his option may consider it as an offer to rescind the contract and excuse his performance, sue immediately on the contract, ignore the AR and continue to encourage the non-breaching party to perform, wait until the contract is actually breached and sue. Right to assurances. If one party believes that a party will not be able to perform, but has not received a complete AR, then the party is entitled to seek assurances from the other party. If the other potentially breaching party does not respond or give assurances, then the other party may be entitled to continue under AR as if the contract was breached. Modification. Under the UCC, one could modify the contract without additional consideration if done in good faith, but the modification is still subject to the statute of frauds. Breach of contract. To prove a breach of contract, the party must prove that the other party has an absolute obligation to perform and has failed to do so. Detrimental reliance. If the court finds that there is no K, it may grant the party relief under a theory of promissory estoppel or detrimental reliance R. Promise unjust enrichment by D if P is not granted relief, reliance by P that is foreseeable, detrimental, and reasonable. Damages. There is a duty to mitigate when one party breaches a contract, i.e. attempt to resell the goods. Minor/material breach. Under common law, whether a party was excused from performance depended on whether the breach was minor or material. If material, then the party is excused from performance, i.e. he is not obligated to pay at all. If minor, then the non-breaching party must complete performance, but may recover damages for the minor breach, must pay contract price minus the cost to buy replacement. Perfect tender. Under UCC, there is perfect tender rule, where one party may reject goods for any reason if it does not comply strictly with the contract in a single transaction, not installation contract. Impracticability. Party may be excused from performance if their performance is impractical, UCC, or impossible, common law. It is impractical when performance would be unreasonably difficult or expensive. 8. The event was unanticipated at the time of the contract. Event occurs after the contract is executed. UCC notes expressly provide for strikes and embargoes as a reason why a contract may be impractical. Impracticability is a subjective test, whether it would be impractical to this D. Impossibility is a higher standard to meet. It is an objective test whether anyone would be able to perform giving the event arriving after execution. Divisible contract. A contract is divisible when it can be divided into sections with each person having an obligation for that division. Governing law. The UCC does not govern because there is no sale of goods. Instead, it is a services contract and the common law governs. Valid contract. A contract requires mutual assent, offer and acceptance, consideration, and no defenses. Definite terms. The offer contained relevant terms, price, subject, time, etc. for performance. Because this is a services contract, the common law mirror image rule applies. Divisible contract. A divisible contract requires that there be an equal number of divisions on each side of the contract. Liquidated damages. Courts will enforce liquidated damages clauses if they are reasonable and it was difficult to forecast the damages at the outset. Contract formation. In order to form a valid contract, there must be an offer, acceptance, and consideration. Offer. An invitation to enter into a contract. Acceptance. Manifestation of intention to enter into a contract. Option contract. In order to form an option contract, there needs to be consideration under common law principles, and under the UCC there needs to be a writing by the seller stating contract will be kept open for a certain time period but doesn't require consideration. Consideration. Bargained for exchange, detrimental reliance or benefit to promisor. Minor under 18. A minor under 18 can contract and doesn't make the contract void just because she was under 18. It only makes the K voidable by the minor, not the other person. Statute of frauds. Requires a contract not able to be performed with 1 year, to be in writing or a contract for the sale of goods over $500. The SOF requires the 1. Name of parties to be charged, 2. Signature of parties, 3. Subject matter, 4. Terms, and the 5. Price. SOF can be overcome by part payment and possession or improvements. In this case, there was only part payment. Anticipatory repudiation. It is where someone in a valid contract states they will not be performing their side of the bargain. To be a repudiation, the words must be certain. Duty of confidentiality. The attorney must keep the case confidential b/t the buyer, client, and the attorney. Punitive damages. Punitive damages are only recoverable for intentional misconduct or gross negligence. In FL, punitive damages are capped at 3 times compensatory or $500,000. If motivated by financial gain, then the cap is 4 times compensatory or $2 million. If an intentional tort or drugs or alcohol involved, then there is no cap. Punitive will not be allowed in this contract's case. Attorney's fees. Generally, each party must pay their own fees. However, in Florida by statute attorney's fees can be awarded in certain cases where manufacturers or sellers defraud or breach contract.